Hi everyone, welcome to session 3 of our ICA post-conference event called Digital Platform Regulation, Beyond Transparency and Openness. Today I'm joined by Fiona Martin from the University of Sydney and Howard Lee from Murdoch University.
Okay, so I'll just begin with some opening remarks by Professor Terry Flew. So the underlying idea behind the digital platform regulation beyond transparency and openness ICA post-conference has been to address the significant change in public and policy discussions around digital platforms that occurred over the course of the 2010s. While that decade started with social media being largely heralded as bringing forth a new era of openness and collaboration, the decade ended with scandals such as Cambridge Analytica, concerns about the role of digital platforms in the dissemination of disinformation and fake news, and the techlash against the perceived monopoly power of the largest digital platform companies in key markets such as search, social media, and digital advertising. Associated with this has been the structural shift in media consumption towards content delivered through digital platforms and the crisis of traditional media industries and professions, most notably news and journalism. Associated with this techlash has been a series of public inquiries, reports, and new laws and policies addressing the power of digital platforms, from perspectives ranging from competition and copyright policy, bargaining relations with traditional media, and content moderation standards. It is estimated that there are or have been over 50 such inquiries taking place around the world. Beyond the content of these inquiries, laws, and reports, they mark a moment where nation states have become increasingly assertive around their powers related to digital platform industries and digital content. The COVID-19 global pandemic has seen digital platform companies strengthen their relative economic position and increasingly appear as public utilities in the age of interconnected yet vulnerable citizens. For reform advocates such as Senator Elizabeth Warren in the United States, this period marked a moment where the public utility dimensions of big tech warrant strong public interest regulations, as well as strong antitrust laws that require structural separation within these tech giants in order to enable fair competition. For instance, separation of Google Search and Google AdSense. Others such as Microsoft CEO Satya Nadella see the times of the pandemic mean that the challenges we face demand an unprecedented alliance between business and government. At the same time, there is a lack of consensus about what digital platform regulation could or should involve. It is unclear, for instance, whether it should involve a refining of existing forms of communications and media policy to incorporate the role now played by digital platforms as quasi-publishers of increasingly popular digital media content, or whether the principal issues such as monopoly power and consumer protection are best addressed by variants of economic policy. The balance between nation-state regulation and supranational governance is also a subject of considerable debate, as is the extent to which soft law and platform brokered arrangements, such as the proposed or now established Facebook Oversight Board or Tim Berners-Lee's contract for the web, may constitute for nation-state regulation. At a time of growing tensions among leading world powers, the divergence between forms of internet governance and the possibility of a global splinternet also needs to be considered. A Chinese digital ecosystem has evolved largely independently of the dominant Western players, and the relationship of the big Chinese tech giants such as Alibaba, Tencent, and Huawei to Western digital markets has increasingly been overlaid with concerns about a new Cold War between the United States and China. And so these are among the many issues that animate this and other panel discussions in this event. So with that, I'll now hand it over to Fiona for her presentation.
Thanks very much, Rosalie. Now I'm just going to share my screen with you. 2 seconds. And That one. Right. Now, hopefully, you will be able to see this. Yeah?
Yes.
Very good. Okay. So I'll start off with an incident in July last year. Germany fined Facebook €2 million using the country's Network Enforcement Act for underreporting public complaints about hate speech and other illegal content on the platform. Now, this is one of these increasing regulatory moves that Terry mentioned in the introduction by nation states looking to control the way that platforms moderate content. And what I'll argue today is that as local political forces seek to shape Facebook's operation, so we're also seeing it glocalising its internal governance processes, its structure, its policy and procedures in response. And what was a very US-centric organisation with universal community standards is having to become more culturally agile and distributed, not only in response to nation-state legislation, but also to boost market growth in other regions, and particularly in this instance, to understand and counter the spread of hate networks. Now, if you recall, Roland Robertson's notion of glocalisation was that globalising trends also involved the reconstruction, in a sense, the production of home, community and locality. And what I want to propose to you is that in trying to regulate harmful content like hate speech to meet its global standards, Facebook's internal governance structure is becoming far more localised in countries outside the US. Today, I'm going to be talking about the complex structure of Facebook's content regulation teams to give you a deeper understanding of its internal governance processes. And I'm going to highlight 3 aspects of localisation in its global governance operations. The increasing number of market specialists, its trusted partner programs, and its intelligence gathering. And I'm looking at how these are developing in response to the rise of hate networks. I'm also going to talk at the end about a point of resistance to localisation, the Facebook Oversight Board that Rosalie mentioned earlier. And I want to weigh up at the end the impact of localisation on Facebook's global operations. So Facebook's content governance operations in Asia aren't well studied, because the majority of regulatory activism around social media platforms has happened in Europe. But as you can see here, Asia has provided some spectacularly awful uses of Facebook to disseminate hate and to mobilise persecution against ethnic minorities, most famously in Myanmar, where Facebook accounts were used to vilify and mobilise attacks on the Rohingya minority, and also where Facebook took down activist accounts that were reporting the violence against the Rohingya. There's also been great concern about Assam, where VARTs found that Facebook had been used to provoke ethnic tensions, especially between Bengalis, Muslims and Hindus. It had been used to incite and condone violence, and again to target the Rohingya refugees in India. So in these cases and others, Facebook has been very publicly criticised for not acting faster to contain the spread of hate speech, notably in the UN's report on violence in Myanmar. Now, Facebook has a really strong incentive to minimise public protest and political interventions around its products in Asia. Asia's been the company's most important region for new growth in total users and in revenue in the past 2 years. The company is also planning on introducing Facebook Pay to Indonesia and India, 2 of the most populous countries in the region. Now, the research that I'm presenting today is actually funded by Facebook in the first round of its Content Policy Research Awards. And one of the things that the team I'm working with from University of Queensland and also University of Sydney is trying to understand is the socio-technological structure of Facebook's content regulation process, so that we can then analyse its flaws and oversights and consider how well placed it is to identify and mitigate hate speech. And today's insights are from interviews and workshops with Facebook staff, staff based at its Singapore and Australian headquarters, from corporate publications and from country case studies. So this is the structure of content governance at Facebook. And can you see the three circles here? They are the three teams that deal with A, policy, public and content policy team, B, content regulation, that's the very euphemistically titled global operations team, as if the rest of Facebook wasn't involved in global operations. And also the third one is product engineering. Now, Facebook likes to talk about how these terms work cross-functionally, but from our research so far, it appears that the policy team leads in terms of responding to critical public concerns about hate speech. Most research on content governance so far has focused on only two areas: public policy responses and moderation, or Sarah T. Roberts' dirty work. However, you can see from the diagram that there's a much wider ecosystem to analyse. You've got the public policy people who are looking after external regulation and government liaison. You've got organic policy, people who develop, apply and communicate Facebook policies internally and externally, and who also manage high-profile content escalations. That's where a critical situation has emerged, like the Christchurch attacks. Stakeholder engagement works with the full range of political groups, non-governmental organisations, and with community education. Communications, we kind of know what they do. Marketing and communicating the corporation's public mission. Security policy is interesting because it looks after issues like disinformation or coordinated inauthentic behaviour. So it has a specific focus on security policy issues. And trust and safety, their work kind of overlaps there. They develop policy and procedures around serious harms like counter-terrorism, pedophilia, and they deal with law enforcement. Now, global operations consists of content moderators. We've heard a lot about the sort of oppressive conditions that they work under, and they're outsourced to companies outside Facebook. But the people you haven't heard so much about are the market specialists and the escalation specialists. Escalation specialists deal with emerging issues and borderline moderation questions, and market specialists operate in key countries and language communities. And then there's the quaintly named community integrity team. So you've got there not only the engineers, but product development people, designers, and technical security people. Now, in terms of localisation, Facebook has for a very long time localised the removal of content to meet national regulation and government requests for takedowns. But there are three key ways in which localisation of Facebook's governance operations is increasing. They're hiring a lot more market specialists. Now, market specialists are the frontline reporters of content regulation and policy issues in the largest language communities and national markets. They don't always cover the smaller language communities, although they try to be aware of what's going on there. And they are sort of the early warning device, identifying and reporting, say, local events that could trigger the posting of harmful content, violating content, as Facebook calls it. They note new examples of hate speech memes, emojis, or unique local terms that are derogatory. And they also then inform content moderation and policy development. So market specialists are called in to review borderline content to determine its degree of harm in a cultural context. And I think that's really important because it's a move away from that broader universal standards approach that Facebook has talked about so extensively. In fact, the woman in front of you calls herself the voice of her community because she's bringing local perspectives to policy debates. The key thing here is it's unclear how publicly visible these people are in each market and how easy it is for Facebook users or concerned organisations to reach them.
5 minutes, Fiona.
Now, the next area of localisation is in the brokering of trusted partners who can provide Facebook reliable information on hate speech and misinformation groups. And the term trusted partners has been used fairly indiscriminately at Facebook to refer to marketing and news partnerships. But the types of relationships we're talking about here are with civil society organisations that are trusted in 3 senses. They have no political affiliations, they are not for profit, and they're publicly seen as impartial, so trusted by Facebook users. And these partners have a direct line to the company to report, say, a new slur against an ethnic minority that Facebook's automated moderation software might not pick up. We were told that finding these partners is very difficult in authoritarian rural countries. Facebook hasn't been able to find a partner in Singapore, for example, because all groups are linked to government in some way. And again, these relationships are not often public, so they're not accountable. And the final area of localisation is intelligence gathering around hate network takedowns. And here Facebook is drawing on informational signals from conflict researchers on the ground, trusted partners and market specialists, or at least where they are in country. Now, this is a different sense of localisation because I'm talking about the way Facebook is patterning group behaviour to identify what it calls dangerous organisations. So it's looking at repeated calls for violence, but also even unbranded personal connections. And so it's localising what it thinks are dangerous or terrorist groups. They have quite different structures. One interviewee noted that religious groups are very hierarchical, while white supremacist or Nazi, neo-Nazi groups tend to be more loosely networked. But once they identify the assets of these groups, the members, supporters, groups and pages, if Facebook considers they're a threat, they will do a network takedown of all of the accounts and without explanation. Now, you might have seen the article in front of you in Mother Jones talking about how Facebook took down a white supremacist group called the Northwest Front. We were told about plans to do the same in the Asian region. I can't tell you where, but if you look at the sort of takedowns that have happened already, for example, Facebook was heavily criticised by human rights and civil society groups last year for banning 4 Myanmar separatist ethnic groups from its site and labelling them terrorist groups. What it's doing is reinforcing the power of a government that has persecuted the Rohingyas and other ethnic minorities. And the problem again is that these takedowns are not transparent and they can have major political consequences. So even though there's localisation, it's not localisation in terms of accountability. And the final point of resistance that I wanted to mention to content governance localisation is the Facebook Oversight Board. Now, it's meant to rule on problematic content moderation and platform use decisions. But in our submission to the original consultations around this, we argued rather than having a central group of 40 individuals, it would be far more effective to have regional boards that can deal with the scope of complaints more effectively, their cultural context, and give the company more local accountability.
1 minute.
As it is, the centralised board's going to be able to, in the words of the US Judge Michael McConnell, who's on it, select just a few flowers, or maybe they're weeds, from a field of possibilities to rule on. Now, to sum up, we can see how in some cases, localised political practices are actually shaping the globalising forces of platformisation at Facebook. More than a decade after its launch, the company has a more culturally diverse policy presence in the Asian region, better understanding of local political dynamics, and better capacity to react to hate speech events, at least in theory. However, the influence of governance localisation is relatively contained. It's also relatively invisible. There's no list of trusted partners or a simple way to provide input to intelligence gathering on hate networks, apart from reporting on the platform. And if we look at the market specialists, they're only in influential markets. We can't find them in the Pacific, in Papua New Guinea, Fiji, or Samoa. Facebook's only moderating in 50 languages, and there are over 2,000 languages in common use in the Asian region. Most Asian employees are still in moderation, working in moderation, the dirty work, rather than in the clean work of governance. And most public accountability is firmly international with a US bias. So what we're seeing is globalisation of Facebook in the sense that John Ari talks about, as globalisation reinforcing the importance of localisation to reinforce globalisation. And I think there's a long way to go before we see more equity in the distribution of the company's resources or its control. And that is it. Thank you so much for listening.
Thank you, Fiona. That was fantastic.
Thank you.
Now we are moving over to Howard Lee to finish the panel.
Okay. Okay, thanks for having me here. Let me see if I can get this. Yeah, okay. I'll start by providing a little context to my topic. It's actually part of my PhD thesis, which deals more broadly with media governance in Singapore. In it, I'll be dealing with how regulation is not simply about laws, but also discursive practices, or what I call disciplining narratives, that goes beyond the execution of laws and regulatory regimes to govern Singapore's media culture as a whole. From this perspective, Singapore's public debate on POFMA, which is our law to tackle so-called fake news, featured prominently as an example of how disciplining narratives take effect. So yeah, this will be chiefly the areas I'm covering for POFMA. But given time constraints, I can only deal with one of the 4 identified segments of the debate in my paper, which is in the main ICA conference. If we can access it, yeah, please feel free to check it out. For today, I'm just looking at one other dimension that was essentially not covered, which is essentially what comes after the law and how it has been used. So just a quick overview of what POFMA means. The Protection from Online Falsehoods and Manipulation Act, that's quite a mouthful, was first mooted as a potential law in April 2017, which Singapore's law minister said initially was a no-brainer. So, and because of that, it became quite surprising when the government convened a parliamentary select committee to study the issue, which was meant to seek public consultation from experts and everyday citizens alike. I myself was a part of that process as well. The entire consultation and review process lasted a year and more before the law was passed eventually in May 2019. And it was first used a month after it came into effect in October 2019. And at the time of preparing this presentation, which is end of April 2020, we have witnessed 15 instances of its use. So what exactly can POFMA be used for? I won't go into the details, but the letter of the law indicates that anything false that is published online and falls afoul of public interest is susceptible to legal penalties. Such penalties so far have been the issuance of correction orders, which basically require content owners to declare that the article identified by the government contained falsehoods, and to add clear signposts to the, within the content to direct readers to the truth as indicated by the government. Now, among the conditions that would subject online content to getting POFMA, as we like to call it, the most controversial has been the 6th condition here, right, which some critics believe allows the government free rein to clamp down on online criticisms against itself. So far, a breakdown of the 15 cases thus far suggests a confirmation of these concerns, with up to 2/3 of such corrections ordered directed at content that affected public confidence in public institutions, which is over here. Just to clarify, this mapping of falsehoods to criteria is a little bit ballpark because the government has actually not indicated clearly in its correction orders which criteria was used for each falsehood identified. So this is really me trying to figure out what to classify it under based on what was basically published by the government. There are elements in the 13th percent, for instance, here, which could actually be attributed to criticisms directed at the government as well. So yeah, so I guess take it with a pinch of salt. It is also worth noting that in the conceptualization of POFMA, a lot of emphasis was placed on foreign threats. So foreign actors who are trying to disrupt our elections and cause disharmony among citizens. However, the usage of the law pointed to more instances of use against local journalists, activists, and opposition political parties. So this usage was eventually carried in Parliament, and especially just after the first 4 cases where a lot of them seemed to be against political parties. And in response to this, the government actually called it a convergence or coincidence, right? The information minister, pictured here, also added, and I quote, if it so happens that some of the people involved are politically affiliated, that's just the consequence of the actions. So in other words, if you're an opposition politician who was POFMA'd, it's basically your fault. Now, it is tempting to say that such actions and defense by the government affirms earlier concerns that POFMA was designed to be abused by the authorities. However, there's a need to consider that acts of coercion need not always yield public outrage. And it's not just because it doesn't concern the broader public, right? But because the public might not actually see anything wrong with it. So for instance, should attention be paid to how biases are essentially part of what we perceive to be normal, be it about fake news, our response to it, and the position of the state versus that of citizens? That is, if citizens see such use of POFMA as being in the national interest, even if it's unfair to those who fell afoul of the law, can we still call it misuse, right? So in my examination of media discourses surrounding POFMA, I've observed a distinctive shift between the initial phase of the debate, over here, when the idea of the law was first introduced, to the last phase where the law was finally passed. A wide spectrum of perceived threats, such as foreign actors, the undermining of Singapore society, political influence, and the destabilization of racial and religious harmony. I know these are rather vague terms already on their own, right? So they've given way to a kind of amalgamation. That is the disruption of public interest by malicious actors. Here. This narrowing of terminology paradoxically has meant a great deal more liberty has been taken with what fake news can mean, and hence a wider scope of what POFMA can potentially cover. So it's kind of strange, see a narrowing, but then narrowing of terms, but it also means a widening of applicability in that sense. The government was also quick to justify more recent uses of POFMA as a means of sanitizing our media environment during the COVID-19 outbreak. Now, we have also been told that the use of correction orders actually allows the truth to be carried with falsehood, and as such does not impact free speech. I mean, you can read into that what you like. But now it is of course necessary to ensure that the right information gets out during a pandemic. And it's just as important to prevent racism and discrimination disguised as free speech. I mean, I think we generally accept that these are essentials. But what we have seen today is that the use of POFMA to date exceeded this mandate. Moreover, thus allowing both sides to be heard actually enhance public debate on public issues. So in that sense, the law itself might not necessarily address some of the issues that it has identified or want to resolve. So what then is the way forward, right? Many who have researched the processes that should rightfully govern the formation of and use of laws and government policy, right? So we acknowledge the need for laws to be sensitive to public response, the need for rules of engagement when using laws, principally when it's used by fairly strong actors, the need to have proper consultation, and the need to accept the faults in established legal processes, right? These are all necessary and important aspects that should be featured in policy making. However, the use of POFMA has revealed that, at least in Singapore, the processes of justifying laws can have a significant impact on how we judge the usage. Even if the bulk of citizens do not agree with how the law is used, does it mean the government is illegitimate in using it? If the government is intent on separating the majority of good citizens from the minority of malicious actors, how do we negate a social desire to play ball with the government, which automatically marginalizes those who don't? How do we deal with not political marginalization, but the politics of marginalization that is played out in public narratives? Sorry, let's go back to what I've pointed out. So yes, unfortunately, I really have more questions for you than I have answers, right? But there's some aspects to the problem that I hope to be able to move on to in the future. It is a problem that I believe is best addressed by localized studies of the response that media audiences have towards such narratives by the government that we find in public debate, as well as a broader examination of how it varies across different societies that have such problems with their communication laws. There are quite a number of countries, I believe, that are trying to implement something like POFMA. And it would be good, I guess, to kind of take a look at how these different societies deal with such laws as well. So what I propose is kind of a two-pronged approach, right? The first is a specific approach that looks at a role that media plays in relation to public communication on laws, as well as a more general approach to examine wider issues of governance and social norms that can affect public trust in government. So for specific directions, we can examine the role of the media in holding public office to account, which will be problematic given that the voice of government do tend to hog headlines, right? How do we bring out all these other voices? Also, how can media give proportionate weight to divergent voices in teasing out things like definitions and solutions to public policy and laws? One of the key criticisms about POFMA was that it was quite poorly defined, and no one knew exactly what the government was trying to target at the point of its conceptualization, although now we might have a better idea. And this is increasingly difficult given that most media outlets are shrinking in size. So we have smaller media who are basically losing the staff, the reporting staff. So how exactly are you able to cover this diversity of views? And if that's the case, then what can we expect of public communicators? People are basically trying to communicate such policies. Do they need to change the way they're doing things? Do we need to have a different kind of standards for how is it that they communicate public policy? For general directions, we can examine some long-standing issues of media governance, which the case of POFMA is exemplified in the context of Singapore. For instance, what is the role of independent bodies for media governance, given an increasingly complex range of issues in the media environment, such as disinformation and partisanship? The concept of a media council, of an independent media council was basically proposed by quite a number of people who made recommendations to how the government can tackle the issue of fake news, and however was not adopted for various reasons. So this is something that we can look at. Another thing is how can societies navigate the ways laws are used and misused, or even how we perceive such misuse? So lots of questions, no answers at this point in time. Hope to find some answers for them in the future. Meanwhile, here's my list of references, and that'll be all I have for you today.
Fantastic. Thanks so much, Howard. That was great.
No worries.